Okay, good morning, everybody, and welcome to our final chapter in abnormal psychology. Yeah, so we're going to be talking about abnormal psychology and the law. All right, there are a number of ways that psychology interconnects, with the law, but particularly with abnormal psychology, we have a number of issues where problems in abnormal psychology intersect with the law, and we'll look at some of the more common ways that happens. Alrighty, so without further ado, alrighty, here we go. Okay, so we will be looking at involuntary commitment, what that is. The insanity plea. I'm sure many of you have heard of the insanity plea. You've seen movies about the insanity plea. So we'll talk about what that law is and some of the issues in this very controversial area of the law and psychology. We will talk about competency to stand trial. And then finally, we'll talk about what malingering is. Yeah. Faking psychological symptoms in this context. And what are some of the common ways that malingerers malinger? Alrighty, so without further ado, let's just bypass some of this, not relevant to us. Okay, involuntary commitment. What this refers to is the involuntary taking of an individual to a psychiatric facility, yeah, for evaluation and or treatment. Okay. Now, in these circumstances, what's at issue in terms of the law is certainly personal liberty, yeah, and constitutional rights in terms of personal agency. Right. As you're all probably well familiar, it is a fundamental pillar of Western, and particularly U.S. law, that the laws protect, that the laws limit personal liberty as minimally as possible. Yeah. Some may argue we do that to a fault, but others argue that it is an important, I think it's an important tradition that we limit the control that the state has over our bodies. Okay. Now, it certainly is relevant in many legal issues, but it's certainly relevant when one is dealing with a psychological crisis, a mental health crisis, such as if they're suicidal and or if they're a danger to others, homicidal. Yeah, and not just your run of the mill, violent person, but we're talking about homicide. Well, here's the thing that's kind of tricky, right? Here in this context, we're talking about a homicidal inclination that's driven by, mental disorder. Yeah, psychological dysfunction, abnormal psychological behavior. But some will argue, might make a very good argument that any kind of homicidal behavior is driven by some kind of psychological disorder. Yeah, maybe not even diagnosable, but clearly some psychological problem. Well, for what it's worth, we're not talking about the things that aren't associated with a mental disorder diagnosis. Here, we're talking about a dangerous behavior to others that are closely tied to a diagnosis or a mental disorder. All righty? Because if someone's a danger and it doesn't seem apparently driven by a psychological diagnosis, they're taken by the police to jail. Okay, not for involuntary commitment. We're talking about a psychological issue. Okay, now besides being a danger to oneself or others, the other basis in many jurisdictions is if one is demonstrating grave disability. Okay. And this is where someone is so impaired by their mental disorder that they are incapable of taking care of themselves. Yeah. Now, this certainly accounts for probably anywhere upwards of 2/3 of those who are homeless. Yeah. It certainly accounts for many people who are incarcerated as well in the jail and prison settings. Yeah. But as a general matter, you can think of grave disability as someone who is so impaired, right? They're incapable of feeding themselves. They may do dangerous things like walk on the freeway because they think it's fun. And the really sad case, which you might see, is someone who's just lying on the sidewalk, in their own feces, not moving, and these really horrifically sad and regrettably not uncommon in urban environments, kind of situation occurs, and certainly can be a basis for an involuntary commitment. All righty. Now, in most states, we have what's referred to as a 3-day letter. Okay. Now, what that means is, well, first take a step back. Okay. If someone is going to be involuntarily committed to a psychiatric facility, it usually requires two physicians. Okay. Most states, it's two MDs, two psychiatrists. Some states may allow for a psychiatrist and a PhD or PsyD. Okay. I don't recall offhand if Hawaii is one of those states. I think we are, but I should know this, but I don't. Sorry. But some states do allow a non MD doctorate, like a PhD in psychology or PsyD, with an MD to certify that someone needs to be involuntarily committed. And again, the bases are the three things that we just mentioned. Yeah, danger to self or others, or grave disability. Yeah, and that it's driven by some kind of mental disorder or diagnosable condition. Okay, it's not just because the person's angry and wants to beat up people. That type of person can, in the absence of a psychological mental disorder, they'll go to jail. There's a place for everybody. All righty. Now, once one is voluntarily committed, one of the things that they have a right to know, yeah, is their right to submit a 3-day letter. Okay. Now, what that means is that upon the individual's involuntary commitment, if they do not consent and they want to get out of the psychiatric facility, all they have to do is write a letter, nothing fancy, right? They could just even write it by hand in very messy handwriting that they want to be let out of the hospital. Okay. It doesn't have to be a letterhead and typed or printed out through a computer printer on Word. Alrighty, as long as it's a basic communication. In fact, I think maybe if someone is incapable of writing, someone else could actually write it for them, and they would sign it in some way. Yeah, but any kind of assertion, right, by writing that they do not consent to the involuntary commitment and they want to be released. Yeah, and in most states, it's referred to as a 3-day letter, because in most states, the person has a right to a hearing within 3 days. It could be the next day, but at least by the 3rd day. Okay, where a judge, and the way it's often done is that the judge comes to the hospital, yeah, and then we'll hear from the physicians, yeah, hear from the patient who's contesting the commitment, and then the judge makes a ruling. Okay, so that's generally how that works. Now, at issue here is the matter of dangerousness. Yeah, and what are some of the problems with this? Yeah, danger to self, danger to others. Yeah. Well, as mentioned earlier, traditionally the Western legal tradition abhors limitations on personal liberty. Yeah. So our Western legal tradition tends to lean on the side of erring on the side of giving the person liberty, autonomy, agency. Yeah. Also related to this is the right to due process. Yeah. Meaning some kind of process where your right is evaluated. Okay. And that goes right to the issue of the 3-day letter that we spoke about. Yeah, that in some it's a 2-day letter, but many it's 3. That's a right of yours, and if it's violated, that's a serious violation on the part of the state, on the part of the hospital, whoever is may be liable in that instance. Okay. The other problem is with science, at least the state of the art of science, as it relates to dangerousness and our ability to, predict dangerousness. As a general matter, I'm not going to go through detailed discussion about this, but clinicians' ability, right, to use clinical judgment in predicting dangerousness is fairly low, like almost 50-50, sometimes below that. Yeah. Depending on the physician, some maybe a little above 50-50, but not that great. Okay. Now, our use of actuarial methods, meaning statistically using, factoring in variables that are predictive of dangerousness. And there are a number of variables that are related to the prediction of dangerousness. Yeah, I believe we've gone through some of those in previous lectures. Are pretty good at determining, the probability that someone may become dangerous again. But the difficulty with even with this science, yeah, even with the actuarial research, which is, far better, superior, fairly consistently superior to just clinical judgment, is the fact that dangerous behavior, for example, like homicidal behavior, are low probability events. They rarely do occur. Yeah, as much as the movies and Netflix might think, violence and murder occurs. That there's a high probability that these things, horrible things, will happen to you. It's actually quite the contrary. It's a low probability event. Yeah. And anything that's a low probability event is hard to predict by way of correlational research. Yeah. So that's also the nature of the science and what we can do either by way of data or by clinical judgment. What we can do is limited. What we can do is we can usually describe one's risk, whether they're low, moderate, or high risk. We're not very good at predicting, with a 90% degree of probability, this person's going to commit murder or assault or something. But can we describe someone as a low risk for violent behavior or high risk? Certainly we can do that. Just as your MD can describe an elderly patient as being a low or high risk of having a heart attack, given their diet, their weight, smoking behavior, and lack of exercise, and all that kind of stuff, which are all variables correlated with heart disease. Similarly, psychologists can do the same with violent behavior. Yeah, if we speak generally about low to high risk. Okay, let me kind of bypass some of this. Okay, let's talk about the insanity plea. All righty. Quite a controversial issue legally, psychologically. Yeah. Now, as a general matter, what's important to keep in mind is that the insanity plea is a legal concept. Whenever you hear discussions in mental health about insanity, right? Odds are they're talking about the legal concept. They might be using it, in terms of traditionally and generally in terms of one's mental state. But really, as a general matter, in professional settings, when you hear the term insanity, it's referring to a legal concept, okay, which is decided by the triers of fact, okay, which in a criminal case would be either a jury or a bench trial, meaning a judge. All right. In different states have different laws about how these things can be adjudicated. Yeah. The other thing to also keep in mind is that a lot of insanity plea cases may actually be pled out, not even in a trial, but before any trial happens, right, or precluding a trial through plea bargaining. All righty. So many insanity cases, I don't know the number offhand, are actually adjudicated by way of plea bargaining. All righty. Not even through a trial. Right. If it's through a trial, then it goes before a trier of fact, like a jury or a judge. Okay. So the laws, the other thing with insanity, in terms of how it's defined, what elements or what things the defendant has to demonstrate, or what has to be demonstrated to determine whether someone is not guilty by reason of insanity differs. All right, we're going to look at one of the, there are about 3 or 4 different definitions. They all vary in terms of some important elements, but we're going to look at the traditional rule, which is the Monocton rule, which is where you have minor variations of the Monocton rule in most states, like New York, and about half the states, like New York, and so on. Okay, and every state makes some modification of the 4 different definitions. All righty. The other thing that's tricky about the insanity plea, okay, is now it's an acquittal, righty, but it's a plea where someone it's referred to as an affirmative defense. Okay, what does that mean? That means that someone is affirming that they committed the act, okay, the violent act, murder, assault, whatever, but they're excused, right? So they're actually saying, yes, I did it, but I have an excuse. My excuse is I didn't have the mental state to commit that crime at the time of the crime. Okay? And that's what's real critical. And that's what sometimes alludes to general public, yeah, is that it's very narrow uh, instance where their mental state is at issue. It's their mental state at the time of the crime, not generally. Okay. Now, certainly, if they had a long history of mental illness up until the incident offense, and if they're still demonstrating these symptoms after the incident offense, that certainly can be evidence, can go to the legal question. But ultimately, the legal question is, at that time, did you have the mens rea or the mental state to commit the crime? Okay. And that's what that's another thing that makes this legal plea, right? Saying that you're not guilty is a plea, guilty is a plea, not guilty by reason of insanity is a plea, right? What makes it so tricky is that the fact finder has to hear evidence about someone's mental state at the time of the crime. Yeah, and although the U.S. Constitution and state constitutions require a speedy trial, yeah, which in most instances means that a criminal trial usually occurs within a year from the time of the offense. Yeah, someone can't be charged and arraigned and then put into jail or prison waiting their trial. They can't wait for it'd be unconstitutional to have someone wait beyond a reasonable time. And in most instances, a reasonable time is usually about a year. Yeah, that's why most criminal trials occur within a year. They have to occur within a reasonable time, like within a year or earlier. Okay, and not much longer than that. That's why you shouldn't hear of people who are languishing in jail or prison for like several years. You got something like that going on, then you probably got a constitutional violation at play. Okay, so because most trials may not occur for a few or several months or even a year or so. Yeah? Now, when if it goes to trial, now the trier of fact has to consider evidence about someone's mental state a year before. So try to imagine that. I mean, it's difficult at times to figure someone's mental state the day before, or a week ago, let alone a year ago. Yeah, and especially if you think about violent crimes and how they're often instantaneous, quick events. Yeah, an assault, a murder. Yeah, no one's assaulted for hours on end, that like torture, right? No one's murdered over hours, right? It's usually someone gets a gun, shoots them, and in seconds someone's dead, usually, right? So that's the thing you got to determine is someone's mental state about a year ago in a very narrow time frame, right? Sometimes moments or seconds. Kind of bypass this. So here's the Monotony rule, okay? And a defendant is entitled to an acquittal if the proof establishes that they suffer from a disease of the mind, okay, that caused a defect in reason, such that the defendant lacked the ability at the time of the crime to either know the wrongfulness of their actions or understand what they were doing. Okay, so there's actually a lot to kind of unpack here. But let's go step by step. Yeah. First of all, if you notice, the rule indicates a disease of the mind. Most of the state laws usually are broad this way. They don't require a specific definition. Yeah. So what a disease of the mind can be broadly construed. Okay. Now, in most cases, it's going to involve a psychiatric diagnosis. Okay. But it could involve some other brain medical diagnosis that isn't typically psychiatric in nature. Okay. That causes a defect in reason. Yeah. So you can see here what's critical is one's thinking process, their logic, yeah, or their ability to perceive things accurately so that they can make a logical decision. So it involves sensations, yeah, what they can see and hear, but also perception, how they organize that information, logical reasoning, all those things, yeah, are thrown in. A defect of cognition. Now, what several states, about 12 to 15, also include is if the disease of the mind causes a defect in impulse control, yeah, in that inability to, not act on your impulses. What's an example, right? If you're hungry, right, and you see someone having lunch next to you, you don't grab their sandwich and start eating it, right? Maybe infants always reach out at people's food, but human beings, Little human beings kind of learn you can't do that, right? That if you got to go to the bathroom, you got to hold it in. That if you want to eat something, you just can't grab someone's food. Or if you have a sexual impulse, you can't just reach out and grab somebody. Okay. So we learn to control our impulses, right? Or manage them in some way, right? So if you're hungry, you go to a water and you don't have food accessible, you might drink some water to kind of, give you a sense of being satiated, Um, but if someone has an impairment, and there are some conditions like psychotic conditions often involve impairments in impulse control. Yeah, for like foods, sexual impulse, and so on, comfort. Yeah. So about 12 to 15 states also allow for that too. It doesn't have to be a demonstration of a defect in reasoning, but if they can demonstrate a defect in impulse control, okay, such that the defendant lacked the ability to either know what they were doing, yeah. So maybe you got a situation where you got psychotic grandpa strangling grandma to death because he thought that grandma was an alien. All right, in that kind of instance, yeah, if someone's so demented, they're hallucinating and they're delusional, right? They think grandma is a space alien out to get them. They clearly didn't know what they were doing. Yeah. But if they strangled grandma knowing it was grandma, but didn't think it was wrong because he thinks grandma's his property, right? And just like any chattel, he can, like shoot a horse dead or shoot grandma dead. He clearly has a bizarre belief system. Yeah, that sounds pretty psychotic. Yeah, regrettably, maybe a few hundred years ago it wasn't that psychotic, right? It was kind of accepted culturally, but now it's clearly deranged to think that way. But that could be a basis for under the prong of wrongfulness, right? They knew what they were doing, but they didn't understand that that was wrong, which it was clearly wrong in that example. Okay, I'm going to bypass the case of Andrea Yates, very classic insanity plea case where she had drowned. What was it? I think it was. I'm sorry, I gotta use the picture here. 4 of her children, she drowned all 4, right, one by one in the bathtub. Now, what she claimed when she was pleading the insanity plea was that she did it because she was convinced she was a evil, bad mother, yeah, and that her children would be overcome by satanic forces, and the only way to save them was to kill them now. All righty. She demonstrated a lot of psychotic symptoms, very kind of robotic. She was developing this kind of bizarre religious, kind of delusion over a period of time, and then she finally acted on it. Okay. Now, what made it kind of tricky was that she drowned each child one at a time, which suggests, very intentional behavior. Yeah, that she knew she was killing them. She knew what she was doing. Yeah, but she was, or her legal defense was making the argument. She didn't know that it was wrong. She thought she was saving them from a damnation or a horrific life or being overcome by satanic forces, I believe, if I remember correctly. And this was a way to save them. Yeah. Now, certainly a very deranged version of Christianity and saving someone's soul. Right? Her brain apparently took it to that extra leap into the deranged arena, thinking that she had to literally save them by murdering them. Alrighty. Now, initially, she didn't get the insanity plea because expert witness for the prosecution had said that what she was presented was actually on an episode of Law and Order. Alrighty. Well, when she was convicted, it later came out that there was never such an episode. The psychiatrist actually, to his credit, discovered his error and then notified the court. And then the court, understanding, taking note of the fact that the psychiatrist had made a misstatement of fact about a TV episode, right? That fact may have actually, been to the defendant's detriment. Yeah, as a jury is thinking, oh, this was on television, she must be faking it, right? She saw it on television, and so on. So the appellate court had ruled for retrial. She was retried, and she got the insanity defense. She was acquitted. Okay, here are a few examples. Let's talk about competency to stand trial, but let me just pause for a moment, get out of here, and let me take a quick break. Okie doke, folks. Thank you for that little break. And let me call back the screen. And with that, competency to stand trial. Now, didn't mention this before, but it's kind of a paradox in that with the insanity plea, in that it causes so much controversy and discussion and debate and dispute. But the reality is that it's rarely used. It's only used in about 1% of criminal trials. Yeah, 1% of criminal trials, I believe, not just cases, but trials. Yeah, so it's one, and in that 1%, it's only successful 10% of the time. Alrighty, so it's not something that comes up very often, and when it is even raised, it's only successful 1 out of 10 times. Okay, now here's the paradox. A thing that doesn't garner nearly as much of attention, sometimes it does depending on the case, but for the most part, is competency to stand trial. Yeah. Now, what does this refer to? Yeah. Well, as the term connotes, it refers to one's ability to understand what's going on in trial. Can they participate in trial? Do they know what's going on? Yeah. We don't want people going through trial who aren't aware of what's going on around them. Okay, that just wouldn't be dignified, and it wouldn't allow them to act upon their agency, right, to assert their rights and so on. Now, interesting enough, even though this does not gather nearly as much attention, I mean, I'm kind of hard pressed to think about, to come up with a movie about the competency to stand trial. Old insanity plea, you know, there's at least a half dozen, at least, movies and TV movies, right, on insanity plea cases. Competency to stand trial doesn't get nearly as much attention, right? Not nearly as sexy, but actually accounts for several thousand cases across the US every year. Alrighty. Maybe it's no surprise that, a lot of people are arrested, maybe suffering from some kind of neurological psychiatric condition, such that they aren't competent to even stand trial. Alrighty. Now, competency, it's called competency to stand trial, but actually competency refers to every stage of the legal process. Yeah. So it refers to someone being charged, someone being arraigned before a judge, yeah, on their charge, and where they plead guilty, not guilty, their ability to plea bargain, their ability to understand the proceedings of a grand jury, if should they be facing a felony charge, right? As you may recall, a grand jury has to always be called upon in a felony case to determine whether this is something, whether the facts support a felony charge. Yeah. And pre-trial hearings, competence refers to pre-trial hearings, refers to trial, refers to sentencing, even refers to execution. Okay, so it refers to every stage of criminal litigation, but it also refers to civil litigation as well, civil matters. Yeah, like to make a will or to establish a trust. Yeah, the person who's establishing those things, right? They have to be competent to make a will, know what they're um, forking over, right, in their will, and the basis for that, and why they're allotting their property to different people in different ways. Okay, will contest in terms of the competency of the person making the will comes up. I don't know what the number is, but it's not uncommon. Alrighty, that competency of the well, first of all, our will contests are fairly frequent. Now, I have to say, I only know anecdotally, but it's sure, boy, in my 55 years on this earth, I can't tell you how many times I've heard either friends or acquaintances, when a family member passes away, that there's a will contest, right? Because somebody is not happy with what they were given or not given a damn thing at all by the person who had deceased. Right, so will contests are fairly common. What the overall number is, I don't know. I don't know where that data might be, if that data even exists anywhere, right? Because people might, contest it and then it never goes to trial, or maybe it's filed for trial, but then it never gets to trial. So I don't know if we have really good numbers on that. But just as an aside, I know I've certainly run into that a whole bunch of times, not in my family, fortunately, but certainly among friends and acquaintances, and you probably will too if you haven't already done so. And among the bases for to contest a will is very often competency. Okay, so here's the case that kind of started it all. Was back in 1916, Dusky v. U.S. Okay, Dusky was charged with murder and convicted. But then when his case was brought on appeal on the issue of his competency, the Supreme Court made this ruling, yeah, that the test for competency must be whether the defendant had sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding, and whether he has a rational as well as factual understanding of the proceedings against him. Okay? And in the absence of that, the person is not fit to stand trial. And if that's the case, if that determination is made by the court, then their trial is put on hold until they eventually do become competent, either typically through treatment, okay, which could be a combination of therapy, psychoeducational interventions, and medication. So the standard definition of competency refers to the person's ability to understand and appreciate the nature and purpose of court proceedings. Yeah. And when we're talking about understanding and appreciating the nature and purpose of court proceedings, yeah, we're not burdening the defendant with having a law school student's knowledge of civil procedure. Yeah. Essentially, the person just needs to have a general basic understanding of what's going on. Yeah. What's the role of the judge? Can you describe that in a sentence? Yeah, like you can say the judge is making sure everyone follows the rules and that both sides are being heard. That would be sufficient if someone were able to articulate that. Okay, to say that the prosecutor is against them, that the lawyer is going to be fighting on their behalf, and so on. Okay, do they know what charges they're up against? Yeah, do they know the difference between an assault, murder, and manslaughter, and a murder one, murder two? Okay, I mean they don't have to. They have to at least know the charges. They don't have to know all the charges and degrees, but the ones relevant to them. Yeah, so if they're facing kidnapping, do they understand and appreciate? And you see those two words, yeah. And in the law, usually the distinction between the two is that if you understand, meaning do you have a logical, factual, do you know what you're facing? You're facing kidnapping. And then appreciate, meaning given those facts, do you have an appreciation for how they relate to you and your circumstances? Yeah. So someone facing kidnapping one, right, ought to appreciate that they're facing something really serious and they could be facing a lot of time. Yeah. And depending on the states, kidnapping can really result in a lengthy sentence. It's really some, I seem to, very often the amount of years you can serve for kidnapping is somewhere between what you would serve for assault or murder. It's really right up there with murder penalties. So states take it really seriously when people are taken against their will or kidnapped. Okay, even if they aren't assaulted or murdered in the process. Yeah, the Western US law has treated that very severely. All righty. As mentioned before, competency applies to every stage of the criminal justice process. Yeah, applies to civil matters. Okay. It's a low threshold, as kind of touched on a moment ago, in terms of what you need to know and appreciate. Yeah. Old joke is all you need to know is the difference between a grapefruit and a judge. Not Judge Judy, by the way. I just used her image. Okay. Very kind of basic understanding. All righty. And the reason, and why is that? Well, the reason why we don't require a whole lot from people is that we just need, well, so first of all, we don't want to burden defendants such that, they never get their day in court, right? So we want to offset a situation where someone is going to an undignified proceeding because they don't know what the heck's going on, versus another situation where we have such high expectations for people to know what's going on that such that they never get their day in trial. It's held off for years, which has some implications too. It may have implications for the defendant's rights. It certainly may have implications for the victim's rights. And as an aside, right, just as in insanity, I don't think we discussed it at length a moment ago, but with insanity, a very common fear is in the general public is that the insanity pleas used as a way to get out of jail, right? That people fake their symptoms so that they won't get convicted. Okay. Now, is it possible that some people, sure, some people have attempted and may have faked, yeah, but as you know, along the lines of the data I just if you take into account the rule and the data in terms of how often it's successful, it's not something that's thrown out there very often, right? Only 1% of cases, and you'll only prevail 1 out of 10 times. Yeah, so there are enough control mechanisms, and the main control mechanisms will be the battle of the experts. Yeah, the defendant's experts versus the prosecution's experts. And at least what the data seems to show is that defendants don't benefit from this the vast majority of the time. Okay, same thing with competency. Yeah, are there certain benefits to delaying one's trial? Certainly, in most criminal trials, it's usually it could be to the defendant's detriment, but in most cases, it's probably to the defendant's benefit. Yeah, well, it's not there to their benefit, spending time in a jail and a locked forensic facility. Okay, but if they're facing really severe charges like a murder or kidnapping, right? It may occur to somebody that it's worthwhile faking it for a year or two in a locked forensic facility or jail, as opposed to facing a life sentence or death penalty. Okay, so you always got to look out for malingering, like insanity cases and in competency to stand trial cases. That always has to be evaluated. Yeah, we'll get to that in a moment. What malingering is. Alrighty. And to be quite frank, malingering has a play in almost every aspect of forensic psych work, whether it's child custody or sexual harassment and claims and so on. But that's kind of beyond the scope of today's discussion. Alrighty. What's important to know, it is certainly relevant in many, if not most, forensic issues, the issue of malingering. Yeah. And certainly in the insanity plea and competency to stand trial. So a lot of the main factors kind of touched on just a moment ago. Is the defendant able to relate to his or her attorney in a reasonable fashion? What is the defendant's understanding of the charges and range of penalties? And what is their ability to manifest appropriate courtroom behavior and testify in a relevant fashion if they choose to do so? Okay. All of these factors, very often the third factor can become kind of tricky to assess, yeah, because it gets to that issue of impulse control. Yeah. So to what extent does person is not able to control their impulses or choosing not to control their impulses can be very, very kind of tricky. Yeah. In terms of their impulse to fly off the handle in a rage and start screaming at the judge or witnesses. To what extent is the person unable to control their emotions, or to what extent are they choosing not to control their emotions? Can be very difficult to discern. And moving right along, let's look at, I think we're going to go right to malingering. Here we go. And if we can just take a moment, let me get out of here. Well, I'll take a moment and I'll be right back. Okay, folks, thanks for the little break. And let us continue with malingering. Alrighty, so malingering is a designation that a psychiatrist, psychologist may make in a chart. It is not a diagnosis per se, right? It's not a disorder, but it is a DSM designation, right? It's a non-disorder designation where one is indicating that individual is making a conscious fabrication or gross exaggeration of physical and or psychological symptoms. Okay, so the person knows they're doing it. That's what you're saying. It's not something that they're not aware of. Okay, like factitious disorders, right? When people fake physical, psychological symptoms like Munchausen's or Munchausen's by proxy, right? Folks like that, arguably, to what extent they're conscious of it is up in the air. Alrighty. Very well, they are doing it intentionally. They know they're making it up, but it's driven by psychological reasons, right? One, it's driven by like a psychological need for attention, to be cared for. Okay. Whether they're conscious of it will vary, right? They certainly will deny it. They may deny it just because they're embarrassed that they're consciously doing this. But you know, it's up for grabs to what extent they're actually aware that they are intentionally faking symptoms. Yeah. Um, but that's not, but even if they're conscious of it, they know darn well that they're making it up. It's still not malingering because they're doing it for psychological needs. Okay. Malingering is done, a conscious fabrication, when it is to achieve an external goal. Okay. Such as getting money, like in a lawsuit, or trying to stay out of jail. All righty. Or avoiding a trial, like in fitness sustained trial. Okay. Now, in terms of determining malingering, okay, most experts in the field will submit that you can't make a determination based on one piece of evidence alone. All righty, that you need to base it on several points of data. Yeah, several instances, maybe testing, a clinical interview with others. Yeah, because first of all, it can be very tricky to determine. Yeah. Um, it's rare that you're going to have a situation where the person's going to be in the room and talking to their spouse and saying, hey, I'm going to fool this doctor. I mean, I suppose, if you happen to walk by and you hear the person telling your spouse, yeah, I'm going to fool this doctor and fake these symptoms so I can get the insanity plea. Yeah, maybe it's just one piece of evidence there. But, in most cases, you're not going to have that juicy piece of evidence, right? You're just going to have a sense that, wow, I think this person's grossly exaggerating and they're consciously making up stuff and they're grossly, or they have some symptoms, but they're, inflating it, okay, exaggerating it. And because people, you aren't going to get that juicy piece of evidence, right? And people aren't going to admit it. It can be hard to discern at times. Yeah. So because in most cases, it's going to be hard to determine. So you need to base it on several points of data. All righty. Now, we're going to pass this, I think. Let me just talk about some classic red flags or rules of thumb. All righty. Some commonly malignant disorders are psychosis, right? And hearing things very typically, memory deficits or amnesia, or PTSD, okay, and being suicidal. All righty. These are very common ones that are raised when people are trying to use it to a legal or financial benefit, some external gain. All righty. Now, that's not to suggest that these things aren't legitimate. They certainly are, and worthy of treatment and so on. But these are often used in part maybe because they're easier to fake than others. All righty. PTSD, sometimes you can have symptoms spaced out by days or weeks or even months, right? So that makes it easier for the faker to not have to always work on presenting symptoms. Yeah. Suicidality can be very tricky too, right? A lot of it can just turn on someone saying, I want to kill myself tomorrow, right? It's not something you can find on a CAT scan or MRI, right? On any other psychological test, right? You may determine that that they're low on depression, but that doesn't mean they're not suicidal. So it can be very tricky. So these are because they may be easier to fake than others. These are some of the common diagnoses. Yeah. By the way, psychosis, it is easy and not. Some things are easier to fake than others. One of the things that's very common in psychosis is thought disorder. And actually, thought disorder is very hard. We spoke about thought disorder in the chapter on schizophrenia, and that is really hard to fake over an extended period of time. Now, one who is truly psychotic, yeah, they'll demonstrate thought disorder 24/7 most of the time, right? With ease because their brain is damaged and their logical thought processes, they're not faking it. It's just that's how they think now. But to do that, to demonstrate that, to articulate illogical thoughts like that on a it's hard to do. Try it sometime. You'll almost start getting dizzy with the effort after a few minutes. Yeah. So it's very tricky to fake. All righty. But hallmark of a psychotic state. The thing that might be easier, not completely easy, but easier will be things like auditory visual hallucinations, saying you're hearing voices and stuff like that. Okay. Now, what are some ways to determine what are some signs of legitimate versus illegitimate or possibly probably, right? Not definitively, but there's a higher probability that they're being faked. Okay. With hallucinations in general, visual, auditory, tactile, olfactory, what have you, if they're reported as constant, yeah, that's usually not the case with most people who experience hallucinations. Yeah, there'll be certain times of the day they hear it more than others. Very typically, when they're stressed, they'll hear voices or see things more. Yeah, but the fakers will usually say they're hearing the voices all the time or seeing things all the time. Okay, the expectation that others will experience. Okay, the hallucinations, to hear the voices. Now, this can vary. Okay, because in actuality, when people are initially they're experiencing symptoms for the first time, they may actually say, "Hey, did you hear that?" Right? Because they're hearing the voices, it's new to them, so they think other people might hear it. Yeah. But if they're claiming that they've had these auditory hallucinations for a long period of time, like several years, right? Most people who've been having these hallucinations for several years, they kind of know other people don't experience it. So non-fakers, you know, understand that other people don't hear it, and that's part of the thing, that difficulty that they're struggling with. Yeah, that perception that they're mentally ill or suffering from something. Okay, so that's just a thing to keep in mind. When is the person asserting or claiming that they've had these? If they've claimed they've had these symptoms for years, and they're asking, "Hey, did you hear that?" Mm, not as likely, right? That's kind of a red, not a rule in, but kind of a red flag that they may be faking it. Okay. If it's reported as frightening to the person, like they're saying, oh, they're breaking out a cold sweat because what the voices say, or the sound of the voice is so frightening. Now, is it possible for someone to report a hallucination that is causing them to experience terror? It's certainly possible, not probable. Yeah. Most people will describe their emotional state related to the hallucinations as a state of anxiety, nervousness, unpleasantness, and so on. Yeah, but not rarely will you hear them describe it as horrific or frightening or they're in terror. Alrighty. Very often, the auditory hallucinations tend to be negative in nature, right? So maybe the person, when they first have the auditory hallucinations, it frightens them. But then after a period of, when they've had these symptoms for a few years, it doesn't frighten them as much. It's just unnerving, yeah, and so on. Now, auditory hallucinations, if they report just noise, it's possible. There are some auditory hallucinations. They can sound like a bunch of jumbled random noise, a bunch of jumbled random uh, series of noises. Yeah. Usually it's a voice saying something to them, usually. Rarely do they claim music. Rarely do people say the voices are unintelligible. And they hear the voices, but I can't understand what a darn thing they're saying. It's usually not the case. They usually, unfortunately, can clearly hear what the voices are saying. And the voices usually say things of a negative or derogatory nature. Okay? You smell, you're horrible, people hate you, stuff like that. Yeah. Now, the particular as auditory hallucinations, you got to be concerned about. It is serious and is a serious risk factor for violent behavior or directive hallucinations, like if they're hearing the voices telling them get a gun and shoot somebody or shoot themselves. Okay, and they're usually negative, as I mentioned before. Yeah, the voices aren't usually saying, "Hey, nice blouse," or "You did well on that quiz." They don't report that for whatever combination of reasons. It tends to be negative. Yeah, probably associated with a negative mood state. That those who are in psychotic conditions are unfortunately very often experience. Okay. Auditory hallucinations are rarely reported as familiar voices. They hear a voice, yeah, but they won't say, "Oh, that's my father" or a friend. Um, Rarely will the voices be non accusatory, as I mentioned before. They usually are accusatory, right? Like you're a fool, you did something bad. Um, if it's perceived as inside the head, it's usually perceived as outside. That's why very often when people are having auditory hallucinations, they'll kind of turn to the left or the right because they're hearing the voices coming from somewhere. Okay. Again, this is not an absolute rule. It may be perceived inside the head, but and again, it's a matter of collecting a number of these characteristics or points of evidence before ever making a determination whether someone is malingering. Okay, it's not in the first person. It's usually you, like you're awful, or you're stupid, or you ought to, whatever. Um, okay, if they have like I said, direct command hallucinations, like or concerning like a command hallucination to cause somebody harm, but sign of fake command hallucination is if the command hallucination has nothing to do with their delusional state, right? So if someone's paranoid, right, the command hallucination might be like, hey, get a stick, the KGB's out to get you. All righty. But if they say they're claiming to be paranoid about the KGB, but then the voice is telling them to steal money from someone's purse, it's like, okay, what's the connection? Okay, so the command hallucinations usually are tightly interwoven, connected with the underlying psychiatric delusion. Okay, visual hallucinations also are rarely instances where people see creatures or people or animals of unrealistic sizes and shapes. Yeah, they're usually they see people or they think they see animals of a normal size and shape. Yeah. Also, as a general matter, when people have visual hallucinations, they usually aren't vivid, yeah, clear images, precise, like as I see you and you see others, like clear, crisp, precise, defined images. Okay. They're usually described as kind of blurs or shadowy images, kind of dreamlike images, not that clear. But again, it's not a hard, fast world. You can have some instances where people have vivid, clear hallucinations. Like, for example, the math um, genius, right, in A Beautiful Mind. He reported very vivid hallucinations of people such that he couldn't discern the hallucination from real people, that the hallucinations were just as solid, clear, and visible to him as the real people were. Right? He often would turn to students and say, hey, can you see somebody there? And a student would say, no, there's no one there. I mean, the guy would say, oh, okay, that's just a hallucination. And with that, that's all I have to say about malingering. Yeah. And with that, that's all. Let me get out of here. That's all I have to say about chapter 15. And that's the end of our video lectures for abnormal psych. I hope you enjoyed our series together, and I enjoyed making them. If you have any suggestions for me as to how I can improve doing the video lectures, please let me know in class when we meet. Otherwise, again, it's been, thank you for the privilege of your attention. And it's been my honor to go over this material with you. And with that, I'll see you in class. Take care. Bye-bye.